The Supreme Court repealed the basic skills requirement earlier this year, but it's my assumption that between pricing and title, this nuts and bolts seminar may attract a fair number of people who've just recently passed the bar in the past year or two or three. When I took the Iowa bar back in 1979, it was written by Iowa lawyers. It was graded by Iowa lawyers. The good side of that was that you took the exam all essay Monday, Tuesday, Wednesday through midday. They were grading them at night with ample amounts of scotch, I'm told. You got the results Thursday and you were sworn in Friday. None of this waiting around for results to get back in. But with the questions being written by Iowa lawyers, you sometimes had elements of parochialism kind of slip in. I remember years later skipping over in class the thresher and corn shellers lane, assuring my students that I'd never be on the bar. And that year there was a heavy thresher corn sheller coverage. My own story was writing the answer to the tax question, and the rule as I remember it is that in order for moving expenses to be deductible, there has to be 50 miles between your old job and your new job. And so I had to begin my answer, having been in Iowa all of 2 days, that assuming that Davenport is more than 50 miles from Sioux City, these expenses would be deductible. The other thing about my taking the Iowa bar is it was my second bar, and I'd been in practice 4 years. And it meant a lot more to me the second time through, actually having represented clients and filed lawsuits and whatnot. Made that doctrine kind of more meaningful. That kind of brings to mind the line I use frequently in class, that becoming a lawyer is a 6 or 7 year process, and that law school only gets you started. And that until you've been out 3 or 4 years, certainly it was my experience that if someone had said, "Is there a lawyer in the room?" right, I would have looked around because I didn't think it was me. I felt I was an imposter. But as I say, with a few years under your belt, it's particularly helpful when you are doing something the second time. Some greater confidence comes. What I'll do with my time today is begin with some context, both for procedure generally as well as for the recent rules that became effective in January of this year, and then move on to text and kind of walk and talk my way through those new rules, projecting their text on the screen and kind of highlighting, drawing to your attention things that I think are most notable. You know, in law school we always debate about whether civil procedure should be the first course in law school or the last course in law school, or whether it should be a first year course or a third year course. And part of that is that procedure is very much kind of the prism or the lens through which substantive law is learned when you're reading those contracts and property and torts cases in your first year. A lot of times it makes a difference whether this is a motion for summary judgment or a motion of failure to state a claim or demurrer, stuff like that. You know, the argument for putting it in the third year is, you know, procedure doesn't exist in a vacuum. It's a means of achieving, of implementing substantive law. The more substantive law you know, the more, to a considerable extent, procedure makes sense. And so we struggle with it a little bit with students in the first year who came to law school thinking they would learn all kinds of things, and at the very bottom of their list was civil procedure. And last spring, I remember at some point I adopted the interjection of you know, hashtag procedure matters to point out in this case or that case how the case really did pivot or rotate on a procedure. And one of the enjoyable things is when people come back from their summer jobs, where that lesson seems to be learned most powerfully. The stuff that as first year students they couldn't necessarily appreciate when they get out there and have their hands on it. So it's my thought that people who've just recently taken the bar maybe kind of having gone back through the general principles of civil procedure. It made it more meaningful than perhaps it was the first time through. I believe that this year's bar exam was the first time civil procedure was on the multi-state. And I saw a news article the other day suggesting that perhaps some of the drop-off in the pass rate was attributable to that circumstance. But you do get out, you start handling cases. You know, in law school we use blanks. Now in practice they're using live ammo. Kind of the lessons become more critical. What I'd like to do is try to, particularly for those of you who perhaps just passed the bar or a year out, kind of draw the connections between what you did study in law school and what, to some extent, I'll be talking about today. Most American law schools focus primarily on the federal rules of civil procedure in their first-year procedure courses. And they do so in part because we don't know where our student's going to end up. And we do so in part because it's a nationally uniform set of rules. And so at least if you end up in federal court, having learned the federal rules of procedure, you might be able to have kind of a leg up getting started. But 95% of litigation in America occurs in state courts. And so kind of an initial observation is the relationship between the federal rules of civil procedure and the rules of civil procedure that apply in state court. I sometimes use the line that if it wasn't for that federalism is this incredibly confounding aspect of the American legal system, and if we didn't have federalism, right, we could cut law school back to about a year. But kind of federalism shows up when we turn to procedure by the relationship between the federal rules and state rules of procedure. And to put that in a little bit of historical context, the big date in first-year procedure court is 1938. Because in 1938 we had two pivots, each going in the opposite direction. Until 1938, there had been vertical uniformity in terms of procedure. That the federal courts simply said, well, we will run our show the same way that the state courts run their shows in the state in which we're located. And so prior to 1938, the Iowa rules of procedure, if there were such a thing, would have been the rules that the federal courts would have followed in hearing certainly any action at law, diversity case, or federal question. And so, you know, that would have made learning the federal rule, you know, kind of, you'd only have to learn one set of rules that you could use in either state court or federal court, that all pursuant to something called the Conformity Act. On the substantive side, right, things were a little bit more confusing. Maybe you remember Erie Railroad versus Tompkins. Swift versus Tyson was an 1840 or something case which declared the power of the federal courts to independently ascertain the substantive common law doctrine. And so even though you had that vertical uniformity on the procedural side, you had disjunction on the substantive side. And a right which was not actionable in state court could be actionable in federal court. Remembering your first year procedure, right, in 1938 there's this change on both fronts. And we get rid of Swift versus Tyson, and pursuant to Erie Railroad, the federal courts apply state law and the content of state law when those issues come up in federal litigation. On the procedural side, we adopted the federal rules of civil procedure, a uniform set of rules that govern litigation everywhere. So you now have vertical disuniformity on the procedural side. You have different rules in federal court than you have in the state court in which that federal court sits. You do have horizontal uniformity in terms of procedure within the federal system to a considerable extent. Wherever you go in the United States, in federal court, you'll be using the federal rules. And you also have that eerie kind of vertical uniformity in terms of substantive law. Now, since 1938, the states have kind of gone three ways. Slightly less than half of them have basically adopted the federal rules. They may be numbered a little bit differently, but they can be 95, 98% congruence. My 4 years in practice in Minnesota, was in such a regime. And so if it was a motion for summary judgment, we looked to Minnesota Rule of Civil Procedure 56. At the other extreme, in some of the larger and older states, Pennsylvania and Massachusetts and Illinois and California, you have procedural regimes that really don't have much to do with the content of the federal rules. And then in the remaining dozen or so cases, states, including Iowa, you have kind of a mixture of the two. There are some portions of Iowa Rules of Civil Procedure that are field code remnants from 1851. And then here and there, stuck in, there are things that are clearly based on the federal rules. In some instances, exactly the same. In other instances, much the same, but with some differences. And that process occurred from the beginning in 1943, after 5 years after the federal rules had been adopted. The Iowa Rules of Civil Procedure were put together. Prior to that time, most rules of procedure were embedded in the Iowa Code. And so a lot of those segments were plucked out of the Iowa Code, legislatively formulated rules of procedure, and put into a separate compendium of court-prescribed procedure. And that's why, particularly in the, I want to say in the 16 series, 611, 612, 613 chapters of the Iowa Code, you'll sometimes see just all kinds of sections that have been repealed with a cross-reference to see Iowa Rules, Civil Procedure, this or that. Table of contents, hopefully you discovered in law school, is your friend. So up here I have the, hopefully, fairly familiar table of contents to the Federal Rules of Civil Procedure. Relatively chronologically presented with kind of beginning, middle, and end, with pleading and parties that then lead to discovery, that then lead to trial and post-trial stuff. The Iowa rules also have a table of contents, but it's about 3 times as long. I think there are almost 4 times as many rules. But one observation is using the feel for procedure, the arc of a lawsuit, the sensitivity procedural issues developed in a first-year course, to, at an initial matter, perhaps start with the Iowa Rules of Civil Procedure table of contents, and either by word or whole searching these days with a PDF, figure out what looks like it could be relevant to your circumstances, and then turn to that and start checking out the text. What I did with this table of contents was highlight a couple of sections to illustrate 2 different dynamics of the newly effective rules I'll be talking about. The expedited civil action is, I'll actually kind of put off for the last part. I think it's the most distinctive, to my mind, perhaps the most interesting, the most exciting of the procedural changes. But because there's nothing like it in the federal rules, and to a considerable extent there's nothing exactly like it anywhere else, it's all there in one rule. And so if you want to know what the update is on expedited civil actions, you can find it in Rule 1.281, stuck on after about 20 rules on the class actions. It makes a little bit of difficulty navigating 1.281 because we've got lots of subsections, but we were kind of sticking it into an existing code structure or existing rule structure, and there was a rule available, and we went with it. We've still got some other ones left. I suppose we could have filled those in, 1.282 to 1.300, but all there in a single rule of about 5 pages. In contrast, the discovery rules are harken back to this procedure or this process of selective incorporation, of picking and choosing, of going through the federal rules primarily, and seeing how things were there presently in a context where some of those have been more recently added, and not, mindlessly, slavishly copying, but rather very selective, picking things that were thought to be suitable to our needs and leaving behind ones that weren't. To a considerable extent, some of the changes the federal rules that we left behind, that we didn't bring in, were addressed to problems of discovery abuse. There are places in this country where what goes around doesn't come around, and someone can be a complete jerk in a lawsuit and never again cross paths with the person on the other side. It was our sense that kind of annoying, obnoxious litigation conduct isn't as significant a problem here in Iowa. We're all nicer than that. And rather than adopt solutions that were in search of problems, we passed on some of the more provisions of the federal rules directed to abusive litigation conduct that we didn't think were necessarily needed here in Iowa. But although there is a discovery division in the Iowa rules, and most of what you need to know about the new changes can be found in two places. 1.507, I guess I didn't properly highlight here. The Discovery Conference will be something I'll talk about in a little bit greater detail, as well as the disclosures in 1.500. But elsewhere, in these other sections, scope of discovery, protective orders, timing sequence, there are little itty-bitty changes. And so I think there are all of about a dozen different rules that were impacted. What I did with the submitted materials is on the first 2 pages provide you with hyperlinks that should work if you have Wi-Fi that will take you to the Supreme Court documents. And if you have that capacity here, the 2 ones that would be most helpful for you to have, and I'll be speaking to, are C1 and C2. I guess I didn't letter them, but they would be in the middle of the first page under the heading Text of Amendments to the Iowa Rules of Civil Procedure. And there you'll have 1.281 as well as the discovery rules. The second thing that's in the seminar materials, with the gracious permission of Professor Doré from Drake, is her article on the Expedited Civil Action Rule that mentions in passing a few of the discovery changes, but focuses primarily on the Expedited Civil Action Rule. And that's just a wonderfully rich, well-developed, you're getting it from the drafter's mouth. She was the reporter. She did the lion's work on the committee. I fully expect that going forward, Doré on the Expedited Civil Action will be like Bonfield on administrative law. You just won't be able to get away from that article. Shout out to her. Being a lawyer is a life of endless change, and in law school I say, well, kind of law school is the on-ramp, and then you get out there on the interstate and traffic is moving and lanes are shifting and things are happening fast. One example of that is, since I submitted these materials less than 2 weeks, the Supreme Court has issued revised Form 2 and Form 3 of Part 23. And so those are not in your materials, but they would be showcased on the front page of the court's website. And again, those changes are in Rule 23.5, Forms 2 and 3. Turning to the last general thought would be about researching issues of civil procedure. If you find one that is patterned after the federal rules, that's very helpful, because you can then kind of link into and take advantage of the much richer body of case law you have throughout the country under the federal rules. Wright and Miller, Moore's Federal Practice, and use that, because Iowa has kind of relatively thin case law, and so you may have to look outside the state court system in order to find some clarifying decisions. If you do have a distinctively Iowa rule of civil procedure, you can go back, but you need to be careful, because procedure tends to be in the background. It doesn't necessarily be in the foreground. And so if you're using an older case, it's always terribly important to verify the content of the rule at that point in time, because these rules have changed frequently. The process seems to be accelerating with the widespread use of the internet. Back in the old days, I don't think we would be pumping out 5 or 6 changes in the course of about a year. But that's what we did with the recent changes. And the thought is, well, you can just go to the website and get the new updated version. Also, if you have any of those green horn books from law school, those are worth keeping around. A lot of the practitioner treatises assume that you know something. And the nice thing about those green horn books is they don't assume you know anything. And so they frequently can do a better job of explaining the why and the wherefore of the provision that you're dealing with. Well, turning to the recent changes, again, it's kind of interesting to think about updates to the Iowa Rules of Civil Procedure, because for those who've just joined the bar, right, they all may be new. But I'm focusing, as I say, on 2 subsets that became effective this year. In terms of the process that gave rise to those sets, the Supreme Court back in 2009, appointed a Iowa Civil Justice Reform Task Force of close to 100 people, and they met for 2 or 3 years and developed a very, very sizable set of information and proposals. Some of those were implemented directly. The business court that I think may have been covered this morning was a proposal that was included in that report. But in the fall of 12, the Supreme Court appointed a follow-on group. It was one of the most awkwardly titled groups I've ever been a part of. It was the Iowa Supreme Court Advisory Committee Concerning Certain Civil Justice Reform Task Force Recommendations. And in her article, Professor Doré mercifully puts in a parenthetical, hereafter, the advisory committee. And in her article, she lists up front who the members of that committee were, but a few pages in, describes them functionally, and I think in terms of the context of these changes. For starters, its chairperson was Justice Mansfield. And I've never had the pleasure before of serving on a committee with a justice as the chair. It's great. People are told to do something, they do it. You know, most of the bar committees I'm on, you know, people are told to do something and they don't do it. But it's very, very nice having a justice chair your committee, because people truly are on their best behavior. But in addition to the justice, we had 3 Iowa District Court judges, 5 private practice attorneys representing both plaintiffs and defendants, defense bars, a government attorney, an in-house counsel, corporate in-house counsel, and Professor Doré and myself. And it was truly a gratifying experience to see this group, it's true of many committees, kind of come into focus and start to get on the same page and move forward and make some progress. But there was, I think, a sense in putting it together, and also in terms of our product, of something that was, to use the phrase, fair and balanced, that we were trying to make the world a better place. Now, Having taught for a number of years at this point, the only truth I think I've come to believe is that many problems started off as solutions. And so I worry that maybe we've done something wrong. But trust me, our hearts were in the right place. We were trying to advance things. Starting with discovery, the discovery changes. These should be familiar to those of you who had federal civil procedure in law school. Because they reflect a process of development in the discovery area in the federal rules. And so going back now 21 years, in 1993, the federal rules for the first time included a disclosures regime instead of discovery, which is available for the asking but does have to be asked for. The disclosure regime imposed a duty on lawyers to offer up, to without being asked, provide information. At the federal level in '93, those things were made subject to an opt-out. It was an optional practice. And I think over the course of the next 6 or 7 years, fully half to two-thirds, including both districts in Iowa, opted out of the disclosure regime. Part of it was a sense that disclosures kind of don't feel right in an adversarial system. The idea that I've got to tell the other side stuff that helps them on my own that maybe they're not quick enough to ask for. One change was made, two changes were made in 2000. For starters, the federal rules were changed to make disclosures required nationwide, except in certain categories or as excused by court order. But the other thing was, we'll see this when we do get to the disclosures in a few minutes, to reduce the scope of disclosures to basically your cards. You don't have to tell the other side about their cards. You just have to tell them about your cards. And that means that we're still going to have your first interrogatories, do you know of any cards that might help my side? So we have this vertical disuniformity. We go on for 15 years where people in federal court are operating under this disclosure regime. People in state court don't have disclosures and are operating under the earlier discovery regime. After 15 years, I'm not sure, I suspect maybe the members of this committee, the advisory committee, perhaps had more exposure to federal court than maybe the average Iowa practitioner. But there was kind of, if you will, good vibes, good feelings about the disclosures. People thought that they seemed to be working. And so they're kind of a two-prong to the discovery thing. The first is a discovery conference, to which we will now turn, which is in Rule 1507. And if you should have those documents up, I'm having trouble getting to them. But the thought was, what we have here is a failure to communicate. If we just got people together and talked, maybe things would proceed more sensibly. And here I'll throw out another buzzword. The history of procedure for the past 3/4 of a century has been transsubstantive, to have one set of procedure that governs all controversies, and that you have the same set of procedure for a slip and fall as you do for a school desegregation case. And that was viewed as problem solutions. That was viewed as a big solution to the problem under the forms of action, where you had, kind of almost case-specific types of procedure. 75 years go by and people are having qualms and questions about the suitability of transsubstantive procedural rules and thinking maybe one size doesn't fit all, that there's something to be said for more adapted, more crafted, more tailored arrangements. And the discovery conference is the kind of thought to be the primary focus, a requirement, picking up there on the third line, 21 days after. I was driving over today thinking how much I don't like deadlines. It's clear that what these changes do is put some very, I would assume, not having practiced law for more than a third of a century, some deadlines that are pretty tight for people who have lots of other things to do other than this particular case. I remember I represented defendants, and so we had this sleeping dog lie mentality that if the plaintiff wasn't going to move the case along, far be it for us to wake them from their slumber, and plaintiffs who had many, many cases would get a case started and satisfy the statute, and then things would lie for a while. And the thought is that, well, sometimes these cases get old and it's harder to recreate what it's about after the fact, months later. And so the thought is real early on. Now that can be, if you obtain service the day you file your petition, that could be 3 weeks after you file your lawsuit. If it took you 90 days to serve process, it could be 111 days. But 21 days after service, after an appearance or an answer, you got to get together. And there are provisions in the rules for what do you do about people who join the lawsuit in process kind of thing. It doesn't include some exempted categories. It doesn't include domestic relation proceedings. There's a separate task force that's working on that, but with one exception, we pulled back from making these procedures applicable to them. So, confer as soon as practicable. What do you do at that conference? Well, sub 2, talk about the lawsuit. Nature of bases, claims, and defenses. Is this something you can settle? What kind of disclosure should we be doing? What kind of discovery do we have to develop? And within 7 days of that, i.e. 28 days from answer or appearance, file a report with the court. And that form is, if I can read these things correctly. Suggested by, and again, this is actually the old form, not the one that was revised a week ago. But kind of a checklist. What we think about trial, who are additional parties, will the pleadings need to be amended, other disclosures, discovery. Kind of instead of an off-the-rack, kind of a bespoke plan for trying this lawsuit, not just any lawsuit, but this lawsuit. And that has to be filed, as I say, 7 days after your conference. So the discovery conference is the first of two major innovations, if you will, or updates, changes in how the Iowa rules operated. Going back to 1-500, however, the disclosures, which would be back at, I think there's 24 pages in this discovery changes because it's dribbled and drabbled throughout. But here, without awaiting a discovery request, you have to provide to the other side information. And this, we've got to scroll down, and I won't because it'll take me, but within 14 days of the discovery conference. So on day 35, a month into the lawsuit, each side is providing the other side. Now here I mentioned the unilateral or asymmetrical nature of the federal discovery regime. You only have to tell the other side about your cards, witnesses or documents that you're going to use to support your claims or defenses, unless you're going to use it solely for impeachment. So if you know of something that's terribly helpful to the other side, but it's not something you're going to use to support your claim or defense, the disclosure regime doesn't apply. Now That change was made in 2000 at the federal rules in part to defang the opposition to disclosures as somehow inconsistent with zealous advocacy. And notwithstanding the fact that that's kind of is a pretty subtle, can quickly go over someone's head, that was carried forward into the Iowa rules. So you still need to send out an interrogatory asking, you know of any witnesses or documents that would help my claims or my defenses? Because the other side doesn't have to disclose those under that formulation. Documents, we fiddled with the federal requirement there to suggest that as a matter of course, normally, it's not, you can come down to my office and sit there and put little, Post-its on the documents you want copied, but as a matter of course to provide copies of the documents that you've identified. Damages calculation, insurance policies, that was when I was in Minnesota, that was one difference. In federal court, you could discover information about insurance. You couldn't in state court. And so if you give lawyers a choice, a forum, they sometimes figure out which one is to their advantage. Obviously, the information isn't admissible evidence, isn't relevant to whether or not there was an accident, but is of immense practical value. And that's part of the disclosures. We then added on, in a way that is different than the federal rules, 3 supplement sections where we do have a claim for personal or emotional injury, specified information, waivers of medical records and things like that. And as the highlighting, that's in addition to A. So everybody's got to give A, disclosures. B, disclosures are add-ons for personal injuries or emotional. C, likewise, is an add-on, claims for lost time or earning capacity. And in there, specified additional forms of additional disclosure required. In contrast, when you get down to D, domestic relations, those disclosures are in lieu of A disclosures. It's A plus B, A plus C. When you get down to D, it's D, but not A. I suppose this was the one place where there was a little bit of mission creep. There was a certain sense that we really shouldn't be treading in the domestic relations area, given that we didn't have any domestic relations lawyers on the committee. But the judges, I think in particular, thought that this disclosure would be a good idea in domestic relations cases. We have some proceedings that are exempt from initial disclosure, juvenile proceedings, mental health, small claims. The two that we understand aren't necessarily bright line, sharp edge, is that the disclosures don't apply in domestic relations proceedings in which there are no contested claims. And they don't apply in foreclosure proceedings in which there are no contested claims. So conceivably, you don't have in a foreclosure any contest. It may just be, yeah, I owe the money, yeah, I haven't paid it, but here's my 6-month demand for delay of sale. Or you could have a consensual division of assets and you're just going in to see the judge. But if there is a contest, then the judgment of the committee, as reflected in the rules, is disclosures would be helpful. That the combination of getting people together to talk about their case and imposing this, offering up of information, the thought would move things forward, would help make litigation more effective and quicker and cheaper. As I say, you've got to get down to F to come up with the 14 days, but if you add that together, 21 days to the conference plus 14 days to make your disclosures, you're up at day 35 with something being filed with the court on day 28. And if you then go to the trial setting conference, which is all the way back in 1906, 21 days, which is the same day as that discovery conference, the clerk provides notice of the civil trial setting conference to all parties not in default. That sets a trial setting conference 35 days, no more than 50. And so if you think about the 35, that's the 21, the 28 with the file with the court, and then the disclosures are there on day 35. So at that point, you kind of laid a foundation for the kind of scheduling that would be appropriate there. So aside from those things, discovery conference, disclosures, there are some little things, a clarified duty of supplementation. Let's see. An adoption pretty close of the federal rules approach to both disclosure and discovery of expert testimony. And in addition to those initial disclosures going back to Rule 500, 1500, there are two additional waves of disclosures. The one I've mentioned is expert disclosure in sub 2. And then finally, pretrial disclosures. As you're coming up on trial and we, fiddled around a little bit, our date is a little tighter than the federal rule, a little closer to trial. Witnesses and depositions and documents, and so 14 days, was heard that, if you got to wrap your brain around a file and then the case gets continued, you're going to have to wrap your head around that file again when it gets continued. So putting it a little bit closer to trial. That duty to make disclosures is not qualified by basis for initial disclosure. H, you must make the initial disclosures based on the information you have available to you at the time. You're not excused from making disclosures because the other side or your party hasn't completed their investigation. So the sense of this is get as much information as you can on the table as early as you reasonably can in the litigation, and that things will proceed better accordingly. I won't go through all of them, but there's also one last thing before we turn to expedited civil actions, is that 2 or 3 places in the rules, before you go see a judge, you have to include a certification that you've spoken with the other side. It's like, Bonfield, a hearing means you got to be able to hear it. And so experience with, emails passing each other like ships in the night led the committee to include that. There's one other thing here I won't take the time to pull up because we're getting moving along, but that is there's an express provision now that allows for the imposition of cost where someone hasn't responded to a discovery request, but lo and behold, they straighten up and fly right, the morning of the hearing. And so that kind of using in effect a show cause proceedings in a particular system is something that the new rules try to discourage. Well, let's go on and talk about expedited civil actions. A little bit easier to navigate here because it's all in one rule and it basically is chronological in sequence with beginning, middle, and end. It starts, there isn't anything exactly like this anywhere in the country. The committee looked at 6 or 7 or 8 systems of what we call 2-tier kind of expedited summary, had different names. They included things like no right of appeal, no right to jury trial. The parties had to agree to it. And based on experience with those systems in these other states, it seemed that they really weren't accomplishing their intended purposes. And so it was a big hurdle, I think, for the committee to work its way through, but would make this a mandatory system at the plaintiff's option. And so if the plaintiff chooses to submit it pursuant to the expedited civil action procedures, the defendant doesn't have any veto. You can get some relief for good cause shown, et cetera. But basically, if the plaintiff wants to be there, then the defendant has to go. $75,000 money damages is in effect a cap. And so if it's got more than that than you're looking for, this is not your cup of tea. But the contention was made is there are a lot of smaller personal injury contract actions where trans-substantive procedure is more process than we need, and it takes too long and it costs too much. The Civil Justice Reform Task Force did surveys about lawyers who were turning clients away because given the cost and expense of ordinary procedure, it just wasn't cost effective. So, as we'll see, this does have some advantages for the plaintiff. It has some advantages for the defendant. And one of those advantages all around would be, and you have to go a little bit back. Oh my God. I can't talk about that. Trial setting. 4 due. The court shall set the expedited civil action for trial on a date certain, which shall be a firm date, unless you move it to another date during the same week, unless the court otherwise orders, expedited, tried within 1 year of filing. And the court system is behind this. The clerks are working hard to make this thing. Again, we're coming up in another couple months on that 1 year period. We'll see how we're doing. But the thought is that, boy, especially in some of the larger counties where cases are being reset repeatedly, this could be something, instead of having to prepare and then re-prepare or have an expert come in and then have him come in a second time. So, quick, cheap, what's not to like if you're a plaintiff? What was to like for the defendant is, and this is kind of my take on it, is that the defense bar said, this is great. We can send a new lawyer in to try a case. I mean, how badly can it go wrong, right? $75,000. If we send a new lawyer in to try a case and the jury comes back with a $700,000 verdict, you got some splaining to do to your client. And so the thought that this expedited civil action would be a way of developing kind of more effective trial advocates by kind of limiting the worst that could happen. So there's a $75,000 cap. It is at the plaintiff's election. There is a provision here for stipulated expedited civil actions. You could have a $5 million case, and if both sides are in agreement, you can go see the judge and ask for it to be tried as a expedited civil action. How do we move things along quickly? Well, we accelerate some of the deadlines. We impose limitations. No more than 10 interrogatories, no more than 10 requests for production, requests for admission, 1 deposition of each party, 2 depositions of non-party witnesses, and 1 retained expert. You can still file your motion to dismiss for failure to state a claim or lack of subject matter jurisdiction or personal jurisdiction. That doesn't buy you time the way it does in a regular action. All the other, the responsibility, you can make your motion to dismiss, but you're going to have to put in your answer. You're going to have to comply with the disclosure regime. Celotex motions. The defense saying the plaintiff doesn't have a case. And here's, a stack of documents 2 feet high showing that the plaintiff doesn't have its case. Those motions can't be made in an expedited civil action. Very limited number, only 1 motion for summary judgment, and on some pretty clearly identified grounds. 90 days before trial. The parties have to jointly propose jury instructions, as we'll see in a minute. We drop the jury from 8 to 6. We allow a non-unanimous verdict after 3 hours rather than, I think it is 6. The trial gives each side 6 hours. And we spent a couple of fruitless hours trying to slice and dice that up between jury selection and opening statements and cross-exams and closing arguments. And just, it's going to be like one of them chess things where you hit the box, You got 6 hours. Use it the way you think best. Ideally, we should have the trial over in 2 days and get a verdict back from the jury on the third day. The court, judges love this. With this joint set of jury instructions, the court doesn't have to make findings of fact and conclusions of law. They can just enter a verdict. The thought is, if jury instructions and a jury verdict gives you a basis for appeal under clear error, why can't we do the same, right? Our judges are up late at night pounding out these findings of fact, conclusions of law, and so, again, it's optional with the court. But if you haven't demanded a jury trial, and you can demand a jury trial, the court has the discretion to use this procedure. You don't like the idea of a verdict of one? Fine. Ask for a jury. But if you don't ask for a jury, this is a possibility. 2 other things that were done. For starters, and this is a little bit more evidence than I'm capable of understanding, but eliminating hearsay requirements to lay foundations for the admission of business records and other things. And so you let the other side know, 90 days ahead of trial, these are the documents I intend to use, and unless the other side raises a substantial question as to authenticity or untrustworthiness, that stuff's coming in. One last was a health care provider statement in lieu of testimony, as opposed to having to pay a treating physician to come in and testify to the injury. Again, doesn't apply to experts, but rather treating physicians, treating health care providers. There is a form that can be filled out, and you can use that at trial rather than calling the health care provider. The defendant has the right to take a deposition of that health care provider, but the thought is, and again, on both sides, that we don't need all that rigmarole to get to the truth of the matter. No ADR, right? If you're doing this expedited civil action, none of this kind of pretrial diversion and go, work it out and go see the settlement conference. And then finally, a requirement of mutuality. I think defense counsel were quite appropriately concerned about getting an adverse issue determination in one of these small takes case that then is cited as issue preclusive. Again, first-year procedure, offensive non-mutual issue preclusion, or offensive non-mutual collateral estoppel. So, by way of context, this expedited civil action rule was put together by people who I think have a very, very strong belief in trial by jury and civil trial. The committee rejected arbitration, mediation. It rejected systems which denied you the right to appeal. It rejected things that qualified the right to a jury trial. As I say, constructed by both judges and lawyers who believe that, at least in these smaller cases, maybe we can try to do better and have quicker and less expensive justice. The results we have by way of utilization. This was through early August. about 230 expedited civil actions filed throughout the state. As we expected, you know, almost half of them being motor vehicle, another quarter being, or another fifth being various kinds of personal injury, and then maybe 40% of it being contract, employment claims, etc. The next page is where those are alphabetical to me. Obviously, I forget what the exact count here is, but there's 40 or 50 counties in the state where there hasn't been an expedited civil action. But in the larger counties, the 8 or 10 or 12 largest counties, where more than half of the state's population is, almost 2/3 of them. And so things like a trial certain within 1 year conceivably mean more to people in Polk County or Lynn County or Scott County than they may in some rural counties where getting that trial date and getting your case tried in a short period of time isn't that large of a challenge. Let me wrap up by reading the last paragraph or two from Professor Doray's article. When I reviewed this in manuscript, I was a little bit dubious, I suppose would be the word, because it begins with an extended description of the centerpiece of Field of Dreams. You know, if Ray Kinsella and baseball, and I got to be careful here because I'm going to do a John Boehner on you. But at the end of her article, Professor Doray closes as follows. And when I got there, I understood why she'd done that at the beginning and told her to keep it in. It works. Only time and experience will determine whether Iowa's new expedited civil action procedure will achieve meaningful savings of time or cost, increase the jury trial rate, or provide greater access to the courts for ordinary citizens. Ultimately, the success of the new rule will depend on its widespread acceptance and use. To paraphrase the mantra heard by fictional Iowa farmer Ray Kinsella, the Iowa Supreme Court has built the AC rule. It will now need to wait and see whether, quote, they will come. We can hope that many years in the future, the ghost of a seasoned trial lawyer will magically appear in a beautiful 19th century Iowa courthouse that once again hums with activity. Judges, lawyers, clients, and jury trials. Is this heaven? The phantom trial lawyer will ask. No. The folks in the courthouse will reply, it's Iowa. So, as I say, to me, it's a very encouraging, hopeful procedural development. As I mentioned at the beginning, I've come to believe that many problems started off solutions, so I lay awake at night thinking that maybe if we come back in 10 years, is this hell? No, it's Iowa. That something may go seriously wrong. But, again, it will not be a function of the committee and the court not having their heart in the right place. It will simply be that maybe we misunderstood something headwise. So, thank you for your attention. My time is up. I guess I have 2 or 3 minutes. If anyone has comments, questions. Anyone have experience with Expedited? Yeah.
Yeah, I do. I just had a kind of a quick question. Under the interrogatory and construction documents, the section of each side gives 10 as opposed to each party. Do you have any kind of clarification on
There is a statement in the rule, and I think that to the extent there was a sense that there are some instances where multiple parties really isn't multiple sides. You know, you have, and so let's see, this would be side. So what would this be? 1I. The term side refers to all the litigants with generally common interest in the litigation. And so I think that it's a functional notion. It's not it's a standard, not a rule. And so I think if you do have a diversity of interest between folks on one side of the V, your argument would be we're not the same side. Anyone else? Again, thank you for your attention.